Everyone. This is Marvin Swartz. I'm with the Department of Psychiatry at Duke, although in this role, I join you as a faculty member of the Wilson Center for Science and Justice at Duke. Just a little housekeeping before we start. If people would turn off their mics, so keep their mics, and actually turn off the video if you could. And it's suggested that you use the active speaker setting on Zoom to focus on the speaker. If you have questions, I think the easiest way we can manage questions is if you put them in chat, and we'll hope to reserve time to follow them up at the end of the presentation. So just to say a little bit about the Wilson Center, it brings together faculty and students at Duke in law, medicine, public policy, and arts and sciences to pursue research, policy, and law reform and education to improve criminal justice outcomes. Our three main areas of foci are accuracy in criminal cases, equity in criminal outcomes, and behavioral health needs. We seek to engage with state and local and community stakeholders to translate research into effective and practical policy. We're very pleased to have Brandon Garrett as the director of the center. He's the L. Neil Williams Jr. Professor of Law at Duke and a leading scholar of criminal justice procedure, scientific evidence, and wrongful convictions. In 2020, the center received a $5 million grant from the Wilson Foundation to fund its research and educational activities, for which we're very grateful, and also a founding grant from the Charles Koch Foundation. Today's panel discussion will focus on the ADA, the Americans with Disabilities Act, that celebrated its 30th anniversary this summer. And today we hope to focus on the central elements of the ADA and its impact on people with behavioral health and other disorders. When President H.W. Bush signed the ADA, he declared it signals the end of the unjustified segregation and exclusion of people with disabilities from the mainstream of American life. Today, we will examine the extent to which that vision has been realized. So our speakers today are Jennifer Mathis, who's Director of Policy and Legal Advocacy at the Bazelon Center of Mental Health Law, John Petrila, who is Vice President of Adult Policy at Meadows Mental Health Policy Institute. He previously was Chair and Professor of Health Policy and Management at the University of South Florida College of Public Health, and Holly Stiles, the Litigation Counsel at Disability Rights of North Carolina. So if each of you, I'll call on you, but could just say a little bit about yourself and the kind of work you do, and then we'll come around again. So let's start with Jennifer.
Hi, so the Bazelon Center is both a litigation shop and a policy shop. So we do litigation, mainly systemic litigation of ADA and Medicaid cases, the other claims too, but primarily I would say that we focus on disability rights through an Americans with Disabilities Act lens and a Medicaid lens. We do litigation around the country. We do big class action cases and similar types of litigation. And we do a lot of policy work. We were involved with the passage of the ADA, with the ADA Amendments Act, with the Affordable Care Act, and most of what happens in Congress and the administrative agencies that relate to mental health and behavioral health, primarily through a kind of rights-oriented lens.
Great, thank you. John?
Thanks, Marvin. The Meadows Mental Health Policy Institute is a nonpartisan policy institute created originally by the Meadows Foundation to try to do something more substantive in Texas with mental health and behavioral health. And the institute's been around 6 years. We do a lot of work with localities across Texas in the areas of adult policy, justice-related issues, children and veterans, and then a lot of work at the Texas legislature. And the Texas legislature, honestly, to my surprise, being new to Texas a few years ago, has invested heavily in mental health in the last 3 sessions. It's created a number of, I think, relatively speaking, far-reaching kind of programs to try to create frameworks for improving mental health care in Texas. Most recently, a program that links university psychiatry departments to primary care docs to try and get better psychiatric consultation in primary care, especially for kids. So it's been an interesting body of work. It's fun to do, and I very much appreciate the opportunity to be here with you and with Jennifer and Holly.
Thank you. Holly?
Yes, I work for Disability Rights North Carolina, which is the protection and advocacy agency for North Carolina. There is a PNA, what we're known as, the acronym, in every state and every territory. And so the PNA system is federally mandated. So there's a series of responsibilities that we have to people with disabilities, and we are the protection and advocacy agency for people with all disabilities in North Carolina. So a lot of disability rights firms and disability rights organizations may have a particular disability focus, but we are the protection and advocacy for all disabilities, which means that we monitor in facilities where people live. We take legal cases, and we function like a private law firm as to litigating the rights of people with disabilities and otherwise enforcing their rights. We do policy work, lobbying work. It really is a broad set of things we do under the umbrella of being the protection and advocacy agency for North Carolina. And for folks who aren't familiar with us, we always like to point out that all of our services are free and that we're not like legal aid and that we don't have income limitations. So millionaires with yachts are eligible for our services as much as anyone else.
That's good to know. Thank you very much. So let's start out with Jennifer. Can you give us an overview of the ADA? What are the central elements and its significance in key areas that affect persons with behavioral health conditions?
Sure. So the ADA is an extremely broad law. It's often called a landmark civil rights law, passed in 1990. And it was based on a prior law, Section 504 of the Rehabilitation Act, which passed in 1973. And Section 504 at that time was basically a sentence, right, that just said, thou shalt not discriminate if you get federal funding, and later was amended to say, or if you're a federal agency. And so what the ADA did in 1990 was vastly expand that reach. So the ADA applies not just to recipients of federal funding. I mean, it doesn't apply necessarily to recipients of federal funding, but for the most part, it will, because they will be covered by the ADA in other ways. But so the ADA has 3 main titles. The first one is employment, and the employment title applies to all employers except for employers with less than 15 employees, fewer than 15 employees. And so all employers are covered, public employers, private employers. The second title is about public services, which is government entities, state and local government entities. So any type of agency, sub-agency, components are all covered under Title II. Entities and buildings, programs, services, and activities run through a public agency are covered under Title II. So courthouses, public mental health systems, police agencies, correctional agencies, jails and prisons, public schools, child welfare systems, public transportation systems, all of that is covered under the public services part of the ADA. Public accommodations is the third main title, and that's privately operated businesses or commercial establishments. So stores, businesses, movie theaters, hotels, doctors' offices, homeless shelters, private schools, etc., are covered under Title III. Now, all of those titles have non-discrimination mandates. So if you're an employer, if you're a public service, a public agency, if you are a public accommodation, you can't discriminate based on disability. And there are both general requirements and more specific requirements. So the general requirements, you can't discriminate, you can't treat people differently based on disability, you can't exclude people based on disability if they're qualified, you can't have policies that tend to screen people out based on disability unless they're absolutely necessary. You have to make reasonable accommodations or reasonable modifications to your services or programs or activities so that people with disabilities can have equal opportunity. Significantly, we'll talk about Olmstead, I think, later in the discussion, but non-discrimination, according to the Supreme Court, under Title II of the ADA includes community integration, includes ensuring that you administer services to people with disabilities in the most integrated setting appropriate. So very, very broad law applying to pretty much, most activities in life, whether it's employment, whether it's through a public service, public program or activity, or public accommodation. Kind of the right to be in the world, I think, is how I would say it, which was actually the words of Jacobus Tenbrook back in the 1940s. But that's essentially what the ADA provides to people with disabilities. And in terms of people with behavioral health disabilities, I think that I would say Title II has been probably the most significant part of the ADA, the public entities title, because that applies to service systems. And so that's really been the engine for big systemic changes. So for Title I, employment, all of these titles have been tremendously important for people with behavioral health issues, but with employment, there tend to be fewer systemic cases for a bunch of reasons. And so it tends to be much more individualized, individual cases where people with psychiatric or substance use disorders have, challenged being excluded from employment, being treated differently in employment, fired in employment, etc. Obviously, tremendously important. Title III, also there have been, I would say, fewer cases overall, but certainly some very significant cases, and not even cases sometimes, but just people have used the ADA to enforce their rights, say with campus mental health issues. Title III is very important for that. Private colleges and universities that may treat people in a discriminatory way based on a mental health issue. And so they're all important, but Title II has really been the engine for Olmstead and getting at public school systems and getting at child welfare systems, public mental health systems for adults, for children, voting systems, licensing systems, bar licensing, other types of licensing, and family and parental rights systems. And so really, I would say that has been the biggest engine for change for people with behavioral health disabilities.
Okay, well, thanks very much. That's a great start to this discussion. John, let me call on you. You asked the question in your 2014 paper in Psychiatric Services, has the ADA been reborn as a tool of broad community change for people with mental disorders? Can you give a bit of your argument in that paper and your subsequent reflections on the topic?
Yeah, so, and I think, again, with Jennifer's overview and Title II is as she said, the part of the ADA that gets to government action in particular. So for a little bit of historic context, I think one of the things that never got solved when mental health law emerged was sort of how to reach expansion of community services. So we had it's ancient history in a sense, but two strands of cases originally, right? One was using challenging civil commitment laws as a way to try and keep people out of long-term confinement in state hospitals. And then we had constitutional litigation trying to improve conditions in state hospitals. But there was never a constitutional theory that reached sort of expansion of community services. So as deinstitutionalization occurred, sort of the issues and the arguments that somehow that was conflated with homelessness and all that sort of thing, there was no federal constitutional sort of theory that would force states to do in communities what states had been forced to do with state hospitals, which was improve conditions. It was also difficult to find a state law theory. There were a couple of cases back when I was in New York. One of the pieces of litigation I was involved in as counsel to the mental health department was, did the state statute that required, that dealt with discharge from state hospitals, did that somehow sort of collaterally create a right to access to housing? And the courts were clear that the state law didn't reach that far. There was an Arizona case, the Maricopa County case, that ended in a massive settlement in which the county agreed to expand community services. That's been going on, a 4-decade history of some of these cases get to do. But there was never anything under either state law or federal constitutional that could reach community service expansion. And so one of the interesting things about the case in New York, which the feds brought, the US versus New York, was it challenged conditions in group homes and said that by institutionalizing people in group homes, which in New York State have always been sort of a massive industry that periodically would emerge in newspaper articles as sort of badly serving people, but never really subject to much scrutiny. A federal judge there held a 5-week trial and found that, in fact, confining folks in those homes violated the Americans with Disabilities Act. And the court was going to fashion pretty broad relief and direct that those 4,000 folks have access to supported housing. Went up to appeal. And one of the issues I think we'll come back to probably with both Jennifer and Holly is sort of ultimately what's going to be the reach of the remedies under the ADA. So the Second Circuit sent the case back, and Governor Cuomo ended up engaging in a settlement. And the settlement agreed to create supported housing for the folks who were represented in the case. And again, about 4,000 people, which to some degree is the tip of the iceberg in terms of the number of people confined in inadequate housing in New York. And some of these homes were huge. They were 120 residents. So these were not small bore placements for people. And so what it appeared to me, given at least the district court's views, was that potentially this filled the missing link, that the ADA could be used theoretically, and in the judge's view, practically, to create an obligation to push the expansion of services in the community. And so it was a really, again, the historic context is relevant because we never had that type of tool before. And so the case potentially created that, again, with some exceptions probably the appellate courts will insist on. And so it was just a very interesting sort of example, both of, in some degree, a governor who wanted probably to get rid of a case, but also wanted, sort of do the right thing and deal with a problem that no other legal theory would reach. And so that was the exciting part of the case, leaving settlement versus Second Circuit opinions and everything aside. So.
Okay, thank you. I hope we come back to that because there are a lot of important issues there, including whether these settlement agreements reach their, end up doing the kind of good that they're intended to, or do legislatures who get the bill balk when the bill comes due. Holly, could you say a little bit about how disability rights has been engaged in ADA action?
Yes, so Jennifer gave us that really helpful overview of the titles of the ADA. So what I thought I would do is talk about some of our representative cases, and that might help kind of illustrate with some real people and real facts how the ADA works in practice. And so Title I is the employment title. And one of the things that Jennifer pointed out is that it has been difficult to get systemic relief under Title I, and there's lots of reasons for that. But one being each employer has their own policies, they have their own procedures. And so what happened to one employee at one workplace may or may not be relevant to what's happening, across the field. But we did have a systemic case that went up to the Fourth Circuit Court of Appeals. It's a case about a young woman with social anxiety disorder. She had gotten a job as a assistant clerk of court in the New Hanover Clerk of Court's office, which is the Wilmington courthouse. And she realized that her job required her to be at the front desk and interact with members of the public. And it was really, really stressful because you had to give answers right away. You were on the spot. And again, she has social anxiety disorder. So she asked the clerk of court if she could be assigned to more responsibilities that were in the back office, if you will, like filing or microfilming things. And that way she wouldn't have to interact with members of the public the majority of her working day. The lower court said she didn't have a disability. So thinking back to what the ADA has meant for people who have behavioral health or mental illness, is for her, because of the ADA Amendments Act of 2008, the law was broadened. The protections it offers were cemented. And so one of the changes in the law was the idea that it was supposed to provide broad coverage. It was not supposed to be difficult to establish that you are a person with a disability. And so as a result of those changes, Ms. Jacob was able to establish in the Fourth Circuit that interacting with others is a major life activity that, if you're substantially limited in that, would be considered a disability. And so we actually have fantastic lawyers like Jennifer Mathis to thank. Jennifer was with the EEOC when they were working on the regulations and helped draft regulatory language that said interacting with others would be an example of a major life activity. And so that's an area where we can see a direct link between the ADA Amendments Act and somebody who had employment rights that were protected and recognized. I did want to talk about two areas of growth in terms of employment rights. So what we're seeing right now is the opioid epidemic. So we have a generation of people who are going to be labeled as substance users. And the question is, are they current substance users, past substance users? Are they protected under the ADA? Because there's an exclusion for people who are active substance users. And so there's just a lot of confusion about when does my rights under the ADA kick in? Is it my first day in recovery? Is it my second day? Is it when I get my 30-day chip? Like, when do I have protection? So that's an area that needs a lot of development, needs a lot of work. Also, for people who do have a significant mental illness, what we see is that there's a lot of missed opportunities, I would say, under the ADA, that, if people have symptoms, behavioral symptoms of their disability, meaning that they act in a way or say something that makes their employer nervous, well, then the employer will fire them, will put them on leave, will take some sort of action that jeopardizes their employment when that behavior is directly tied to their disability. And so what happens is, because you manifest the symptoms of your disability, you may lose your job. So what are the protections in the ADA? I mean, essentially they are just, they disappear for people with mental illness most of the time because of a concept of direct threat. That if I am someone that my employer is concerned it's a direct threat, then it's okay to fire them. So that's a whole group of people that are being excluded. And I did want to respond that I think I've give somebody a microphone, you know, they love to talk. So I think I've gone a little long, but I wanted to respond to John's point about the group homes and the community-based services and living in the community. One thing that North Carolina did back in the 80s was a case known as Thomas S. And as a result of that case, there was actually a recognition that your liberty interest, your right to due process and equal protection extended to the right to live in the community. And so as a result of that case in North Carolina, there was a very robust system established for people to live in the community with support and have, you know, a full life. Unfortunately, like so many things that start off so well, it has just eroded and disappeared over time. So we certainly see opportunities in that area to strengthen that, because we are an institutionalized state. That's the sad reality.
Thank you. Thank you. So Jennifer, coming back to you, let's focus for a moment on Olmstead. What's the significance been of the ADA related Supreme Court decision in Olmstead, and how has it affected integration of persons with behavioral health conditions in community settings? As Holly points out, there's been a lot of activity related to Olmstead in North Carolina and the notion of trans institutionalization. But can you say something about Olmstead and its significance in this regard?
Sure. So, yeah, I think that Olmstead, which was the Supreme Court decision that interpreted the ADA's integration, the ADA to have an integration mandate to require public entities to administer services to people with disabilities, including psychiatric disabilities, in the most integrated setting appropriate. I would say Olmstead has been the most significant development for community mental health systems in the last 30 years. I mean, I think you can put Olmstead up there with the Affordable Care Act, and those things have really created more change than like anything else, any other type of advocacy, I think, over the past 30 years or so. Sometimes Olmstead has been referred to as kind of the disability community's Brown versus Board of Education. It really, was a just vastly significant decision, and there had been many efforts before that decision to try to get to community integration other ways. And as John sort of alluded to, most of them had not been terribly successful. There were some efforts. Holly talked about Thomas S., and there was a case called Clark v. Cohen in Pennsylvania that sort of established maybe a constitutional right to community services in certain circumstances, but the ADA really, I think, and Olmstead dramatically expanded, the establishment of what that was and what that looked like. And so I think that one of the things that was most significant was the Justice Department's prioritizing of Olmstead during the Obama administration. That became a top priority. And it really, I think, shifted, state service systems, how they operate, how they plan, how they think about their mental health service systems. There were many settlements. John talked about the adult homes case in New York. That was actually our case. And it was, I would say, probably the foundation of modern Olmstead law. A lot of things were built on the shoulders of that case. But you had settlements in New York, New Jersey, Illinois, Georgia, Delaware, North Carolina, Connecticut, Florida, New Hampshire, Oregon. Those are just adult cases. You had kids' mental health settlements, Olmstead settlements in California, Massachusetts, Washington, West Virginia, some court rulings, court orders, some settlements, mostly settlements. And I think that those things have had a collective impact. really tens of thousands of people with disabilities have gotten the opportunity to transition from institutional settings to supported housing or sometimes other community settings as a result of those settlements. But it's also had a far greater impact than just the litigation, just the settlements. I think it really has shifted what states do because of the awareness of those settlements, and people can see that you have exposure if you don't develop sufficient community services. I would say nobody has sufficient community services yet, but it has certainly created a significant change in how states and localities, but mainly states, do business. And the Justice Department's involvement in this, I think, made an enormous difference. Before that, it was just private litigants like us and the P&As doing a lot of that litigation. And with the Justice Department, I think the prospect of the federal government, the United States, coming after states for not complying with the law really was noticed, right? And made a significant difference. And so, I don't think that we are anywhere close to what I would consider compliance, full compliance with the integration mandate anywhere, but certainly we have made enormous strides. Certainly Olmstead is taken seriously now. Certainly you can see it in the planning and in the development of mental health service systems and the focus on developing integrated community services. We still have certainly plenty of trans-institutionalization. A lot of what happened when state psychiatric hospitals downsized or closed was the development of sort of an industry of these boarding care homes and nursing homes and other large congregate settings that developed to kind of take people out of the hospitals rather than really the development of good integrated intensive community services. And I do think that these Olmstead settlements have really driven more of a focus certainly on those types of services, on supported housing, supported employment, peer support services, assertive community treatment, and intensive case management. And so, that is still, it's a long slog. And honestly, I'd say Olmstead has gotten to what I consider the heart of the ADA. When President Bush Sr. signed the ADA, and he said, "Let the shameful walls of exclusion come tumbling down." There is no greater exclusion than really sort of confining people or segregating people in these institutional settings. And this is really, it gets to the heart of how people see people with disabilities, how people think about them and their capabilities and where they belong and what they can do. And so I think naturally, when you have something that is so fundamental and so reflects, decades of attitudes toward people with disabilities, it doesn't change overnight. This is a long haul. This is, a process in development. But I would say that, Olmstead certainly has been tremendously significant in moving us along that trajectory. And we have seen that it's not only applied to living settings, but we saw, I think, some development of Olmstead 2.0 and 3.0 and 4.0, which is Olmstead as applied to employment settings, Olmstead as applied to education settings. So, you have people with disabilities working in sheltered workshops or in segregated day programs instead of getting supported employment services. And, you now have some Olmstead law saying that's an ADA violation, right? And in education, it was kind of a new thing. People always thought, oh, the IDEA is the only thing. The Individuals with Disabilities Education Act is the thing that applies to kids with disabilities in schools. Well, Title II of the ADA applies to all public services. All means all public services programs and activities. And so, you had the Justice Department enforcing the ADA in education and saying you can't segregate kids with mental health disabilities in segregated classrooms and segregated schools if they can be served in a mainstream regular classroom in a regular school. And so you have Olmstead applied to education also, and now we're starting to see Olmstead applied in criminal justice. So I think, certainly hard to overestimate the impact that Olmstead has had on behavioral health.
Marvin, I just want to just jump in very quickly. I just want to say to Jennifer's point about Olmstead and all the things that it provides, the thing that people will automatically think is, but it's so expensive. And what we know is that serving people in the community is cheaper than serving people in large institutions. And in North Carolina, our housing finance agency has sent back money for affordable housing, specifically housing targeting people with disabilities. So we have the money. It's not about the money. I just want to put that out there.
Fair point. So, John, let me follow up a little bit on some of the issues you raised previously and in your paper. And really, it's about the sort of when you have a settlement or a consent decree, and maybe you could distinguish how the differences. What is the path to successful implementation versus sort of incomplete implementation? Because as I referenced before, so say Governor Cuomo initiates a settlement decree, the bill goes to the legislature and they can be pushed back there. So what are the elements that makes real change happen when you have some of this litigation?
Well, I'll reflect on that as someone who represented a large state agency, and then Jennifer and Holly as plaintiff lawyers may have kind of different views. So to build on one or two things Jennifer said that I think are relevant, Marvin, to your question. One is that there is sort of a psychology to how state agency counsel deal with these cases. So there was a period in sort of as constitutional litigation emerged where states tend to settle cases for a lot of different reasons. And then states started not settling cases as willingly. And that's important because we're dealing with a federal court system. Remember, one thing the Trump administration has been very successful at is flooding the federal judiciary with very conservative judges. And it's a Supreme Court that gutted the Voting Rights Act. So for Olmstead to retain its power, I think, in an ideal world, we would avoid testing whether the Supreme Court would ultimately sort of rethink its application. And, it's one of the issues in the hearings, right, that just concluded. What's precedent, what's super precedent. So those are all relevant, sort of the psychology of these things are relevant. So that's one thing. Second thing is sort of, if when I was a defending states, what I wanted was a consent decree that gave us the broadest discretion possible in implementation. What plaintiffs typically wanted was things that could be counted. And there were, so there was like a kind of a basic, the battle was over sort of specifics in the order, who was going to monitor, et cetera, et cetera, et cetera. And, I'm mindful of a case like Wyatt, right? The first big Wyatt versus Stickney. Probably half the people on this call, not half, you, others, right? At some point or another, we were asked to be a part of that case. It went on for 40 years. And so the other thing you want to do as a state, I think, is, and assuming good faith on the part of the state in this case, you want something that can be implemented and then move on. And so part of the struggle then is sort of what does constitute sort of compliance or adherence with something you've settled to, and people game it, right? One of the ways Alabama dealt with the orders to increase staffing ratios in a state hospital was just discharge people to nothing because they were dealing with ratios. So there's ways to game these decrees as well. And I think one of the things you want to try to figure out is where's the sweet spot between giving people in good faith what you have agreed to provide them, but not getting lost in a 30-year battle over sort of compliance. And again, that all sounds vague, but there is kind of a psychology to this that Jennifer and Holly may have thoughts about as well. But that was my kind of view of it. Again, just one last comment. We have a Supreme Court now that decides fewer cases than ever. To me, they're basically a court devoted to adjudicating corporate interests more than anything else. It's inconceivable to me that they would do what the courts originally did after Olmstead or after the ADA was enacted, which is hear 18 or so cases about the ADA, and generally speaking, kind of come out to what I would view as kind of the right side of those cases. So I'll stop there.
Okay, thanks. Holly, I want to shift a little bit and ask you to reflect on this vis-a-vis COVID, because we'd be remiss not to talk about that. Have you had COVID-related issues that also touch on the ADA?
Absolutely. So one of the things about COVID is that it loves congregate settings. And so if you are a state like North Carolina, where we deliver mental health services, we deliver employment services, and we just have a lot of facilities, then you're going to invite COVID to just run rampant through those facilities. And we've seen that. The data shows that the incidence of COVID in nursing homes and assisted living and our state psychiatric hospitals and our prisons and our jails is just undeniable. So COVID has definitely been an issue. So where it comes, where it affects people in their day-to-day lives that don't live in facilities, for example, is for students in K through 12 education that receive Medicaid-funded behavioral health services, for example, or assistance with daily living. Those students would typically be in school from 8 to 3, so whatever the school hours are. And so they're at home right now, and Medicaid says if you're in school, we don't pay for your services. And so there's had to the state had to request a waiver and did receive a waiver that would allow people to get support at home, because obviously school staff is not going to come to your house and provide the support that you were getting in the classroom. So that was a big issue for students related to COVID. There's also been a lot of telehealth and telemedicine authorizations that weren't possible before. Again, they had to get permission from Centers for Medicare and Medicaid Services in order to start delivering behavioral health or other medical services over video connection. So that's been another issue. We still have a lot of sheltered workshops in our state. So people who were going to a facility and working every day, they have been home, many of them, with no substitute. And again, the idea that we don't provide supported employment, instead we provide a congregate facility-based employment service, means that those folks were deeply impacted by COVID. So that's where we've seen COVID directly impact folks. What I'm particularly concerned about right now is the amount of people who are going to be disenfranchised in this election. So we have again, we have a lot of facilities, and right now most of them have no visitor orders, which means that volunteers from the County Board of Elections can't go to those facilities and help people vote their absentee ballots, which is something that, voting can be complicated. You've got to fill out a form, you have to send that form in, you have to wait for the form to come back. And then if you're somebody who can't hold a pen, isn't a strong reader, whatever your reason may be for requesting that assistance, the volunteers aren't being allowed to come in and help you with that. And then we have a state law that prohibits employees of those facilities from helping them. So these folks are really facing appears to be no viable way to cast their ballot unless there was some sort of a groundswell of community volunteers that were somehow able to overcome the no visitor restriction. So that's been something weighing heavily on our minds as we come up on November 3rd, is that the overwhelming number of people, we're talking hundreds, if not thousands of people who want to vote and will have no way to do it in November.
Thank you. Well, let me go back to and let you each comment on this issue of the Supreme Court. It seems to me that there's an issue of the Supreme Court and the extent to which they support the ADA or narrow the ADA. As John referenced, it looked like the ADA was on a path to irrelevance until the Congress amended it, which was an interesting development. But do you all feel there's a threat now to the ADA with the probable tilt to 6-3 in the Supreme Court? And also, what is the significance of the from the executive branch, the Department of Justice, and the extent to which they pursue these claims? You want to start, Jennifer?
Sure. So yes, I mean, I think the Supreme Court obviously has been very significant as a source of, what the law means, and Congress can pass laws and they get taken apart sometimes by the Supreme Court or invalidated. I would say, the ADA, I wouldn't say it was on a path to irrelevance, but certainly it had been much less usable by people, at least with certain types of disabilities, primarily diabetes and epilepsy, and to some extent, psychiatric disabilities, to some extent, some other disabilities. We still obviously, used it in pretty significant ways during those years before the ADA Amendments Act. But yes, obviously the ADA Amendments Act helped a lot, and it's hard to keep going and running back to Congress every time that the courts mess something up. Kai Feldblum once said, I think on the 20th anniversary of the ADA, she said, it's like the ADA's 20th birthday and it's kind of my child in a way. She was one of the people who helped craft the ADA and secure its passage. And I used to say, it's like when your kid comes home from college with a nose ring and purple hair and, unrecognizable, and, you got to fix it. And so, that was the ADA Amendments Act. But, I do think that our life has been, in terms of litigation, a lot of, times has been spent keeping things out of the Supreme Court, right? Whether it's the ADA or anything we care about, just keeping it out of the Supreme Court has been the goal for quite some time. Now, I think it will be even more so. Sorry, my kid is having a meltdown in the next room. But anyway, so I do think, and there was a time when actually Olmstead almost got up to the Supreme Court a number of years ago. Washington State had a cert petition that they had filed, and there was a lot of advocacy to try to settle that case and keep it out of the Supreme Court, because we don't know what the Supreme Court would do today. But I would just say that, it takes a long time for things to get to the Supreme Court typically. And so, yes, it is true that certainly the federal judiciary looks significantly different from, what it looked like a few years ago. But I don't think it's closed. Certainly people, I think now, look more or are thinking about looking more to state courts and state law for, significant change in many areas. But, I think it does create a significant threat to people with disabilities. And I think the nominee that we have now has pretty much said pretty clearly that she thinks the Affordable Care Act is unconstitutional. And so, yes, we will, I think, have a lot of work to do if this nomination gets confirmed.
Thank you. John, what about this issue about the Department of Justice? You have sort of a bizarre situation where the Department of Justice is not defending the ACA and actually attacking the ACA in the challenges. Where do you see the Department of Justice in the future with this?
Well, it's hard to predict, obviously. And again, I think Jennifer knows folks there probably in a way that I don't, or Holly, because of their constant immersion in this issue. But I guess a couple of comments. One is that I, at least sort of by inference, give credit to the staff lawyers who staff this issue in DOJ that they have not asked for sort of the gutting of the ADA. And that may sound like faint credit, but it's real credit, right? Because one of the sort of initial orders that the president gave after assuming office was withdrawing a lot of regulations, some of which went to extension of the ADA to folks in terms of accessing basic medical care. And so I think that the legal foundation that's been established by folks like Jennifer and Holly and others is still intact. And that what the Justice Department does obviously matters. And again, that may sound trite, but I think we've learned, you learn by these vast contrasts in administration what really does matter over time. And, the civil rights group within the Department of Justice had enormous influence for years on institutional litigation under George W. Bush. They had an enormous impact on conditions for kids in juvenile detention because they made that a centerpiece of their work. And so what I think is good is that the legal foundation exists. And I think, and again, Jennifer and Holly may have a different view, but in my view, it's still pretty intact. And that it does create a vehicle. And I would assume the next administration will, if Biden wins the election, then I assume that administration will take that foundation and push more aggressively. And it's for other contextual issues. Holly mentioned COVID for sure. But one of the other ways, and again, some of the strategy of folks like the Bazelon Center and Disability Rights Center has been to link Olmstead and kind of its core principles to Medicaid funding and things like that, which is also, you got to have the financial tools. And, there's been decades, it seems, of litigation where the courts have said payers have almost an absolute right to set the terms of payment, right? In commercial insurance, it's negotiation with ERISA. With Medicaid, it's sort of federal and state, blah, blah, blah. So I think that extension of Olmstead to the financing of care may become even more explicit. So in that sense, I am optimistic given the continued sort of steadiness of the legal foundation. It seems to have survived intact, whether it's used aggressively being a somewhat different question.
Holly, your thoughts on this?
Yeah, I'm thinking of this from a North Carolina perspective specifically. And so what we've seen is that the right to live in the community is sort of a super precedent at this point. Like everyone accepts that to be true. But then making it happen is where we continue to just struggle. And so the ADA has two primary affirmative defenses, the undue burden defense and the fundamental alteration defense. And so while there's a recognition that every single person has a right to live in the community, arguments continue to be made about, well, it'll be too hard to restructure our system. It'll be so expensive to set up, individual supported living type arrangements. And so that's sort of like that's the tension point, is that there's a recognition that absolutely this is something that every person has a right to. And then on the other hand, but how do we make it happen? And so, for example, Disability Rights North Carolina seceded in a lawsuit against the state about the continued institutionalization of people with developmental disabilities. We still have developmental disability centers. And the state essentially said, yeah, but now what? Okay, so we're institutionalizing people. And so then the remedy, and that's what we've talked about before, is what is the remedy? And I think the crisis and every remedy is whether or not there's going to be real meaningful change on the part of the system that is administering these services, and whether or not that change will result in an embrace of prioritizing community services over institutionalization. And so I think in every state, there's a fight for the soul of the service system. Is, what's it going to be? and I think sometimes it'll understand one part of it. It'll understand employment and say, yes, we understand that having jobs and being able to support yourself is super, super important, but maybe not understand why continuing to offer day programs instead of competitive employment, is important. So I think that's really where we are. We're fighting for the soul of the service system.
Right. Oh, thank you. I want to remind folks that we have a couple minutes, so if you want to pose any questions, please do. We have a question from Jasmine Harris on the remedy point. Is there room for using the ADA? Whoops. Sorry. Is there room for using the ADA as a tool of deinstitutionalization today? Decarceration, abolition movements are tied to disability rights. Anybody want to jump in on that?
So, I mean, this is Jennifer. I guess I'll just say, yeah, absolutely. And we still are using it, in that way. I think, I'm proud of a case. I don't know, what will happen with it, but that we just filed with the PNA in California around needless cycling of people with serious mental illnesses into the county psychiatric hospital in Alameda County and into the county jail because of the insufficiencies in the community service system. And that is an Olmstead case. And it is, sort of focused on the same sets of community services, the same services that prevent people from going into psychiatric hospitals or put them at risk of that. Also, the lack of those services puts people at risk of needless incarceration. And, I think this is sort of the next wave of Olmstead. This is, a lot of where people are focused today. And I do think that, the ADA is a tool to do that. And it does apply pretty squarely in this context. And so, yes, we do have courts that I think, are more challenging in general for these claims, but, people still have been it hasn't put a halt to ADA claims, at least at this point. So absolutely.
Yeah, I would say as mental health advocates who were focused almost exclusively on the implications of Olmstead for hospitals, I think really had their eyes and minds opened by the idea that while there were these folks who were trans-institutionalized and put into really inadequate large group homes where they didn't enjoy freedom or inclusion or adequate services. So I think that has been an ongoing, revelation to mental health advocates. And also, I think to John's point, the extent to which it's been a lever to try to implement evidence-based practices and get people good treatment has also been a revelation. Not only deinstitutionalization, but the revitalization of the idea of right to treatment that, as John said, really didn't have a good constitutional theory to implement. Well, I want to thank everybody for a terrific discussion. This has really been wonderful. I want to thank Jennifer and Holly and John for this. And if anyone has questions, we can also, try to get some more input from these three excellent speakers. So thanks everyone for their participation, and hope to see you again soon. Thank you.
Thanks.